people, welcome back again to another video. If you are new in this channel, this is Officialsharon&Entertainment, a home of freedom fighters. If you haven't joined our family yet, join the family by hitting the red button down below on the bell notification icon, so whenever we have a new video in this same channel, you will get notified. Thank you so much for tuning in, and I love you all. So my people, I have a video here that I want you all to watch, and I myself will be watching with you in this particular video. Feel free to let me know what you think about this video in the comment section below. Like and share this video, and I will see you again in my next video. Bye.
So self-determination is really what it's about. Every other thing that is coming out of that is secondary, subsidiary. A lot of people are calling it an arrest, but it's not. Actually, in the eyes of the law, not only international law, but even Nigeria's municipal laws, it's an abduction. Because he was seized. The act of taking him, the physical act of taking him, did not satisfy the elements of an arrest. He was abducted forcibly without due process of law and ultimately transferred to Nigeria in circumstances that are known in international law as extraordinary rendition. So that really is what we should pivot on and look at the consequences of such action. Because when you call it an arrest, you sort of give it a modicum of legality, which this one doesn't have. So for that reason, we have seen enough cause, enough grounds to challenge what happened and use it to interrogate, the question, the jurisdiction of the territory of Nigeria to put him to trial. Because extraordinary rendition is unarguably, universally agreed to be a crime by the state. Even though the state is beyond the physical punishment for a crime, there are other ways you can exact a retribution against a state that engages in such act of criminality. And one of the ways is to do restitution, to restore the person you rendition to the condition that he was before you renditioned him, compensation and guarantees of being of good behavior in the future anytime you encounter that person. These things are provided for clearly in a lot of provisions of international law and treaties, protocols, conventions to which Nigeria and Kenya are subject. So it's either Nigeria did not think too much about it, or it did not know, or it did, but somebody decided to act in this arbitrary manner that is bound to raise a lot of legal issues. So I can give you an example. The African Charter on Human and People's Rights was ratified by Nigeria in 1983. And not only ratification, Nigeria domesticated it. That means Nigeria made it part of its own laws. And our constitution says once you ratify a treaty or some kind of international agreement or something that you made with another nation, once it's ratified, I think it's in section 8 or section 9 of the constitution, I'm not so sure of the section, it becomes part of our own law. So for Nigeria to go against the treaty is akin to Nigeria going against its own law. So this treaty that was ratified in 1983 contains a provision in its guidelines that mentioned extraordinary rendition. It mentioned it. It's not by implication. It mentioned it and said, extraordinary rendition is hereby prohibited. And that nobody, no human being, no individual shall be taken from the territory of another state and transferred to the custody of another without due process of law. Nigeria signed on to this. So Nigeria is going to be held to what it signed. Well, yes, that's what they said, that's the accusation. Because I think it was to give a little more legality or justification to the manner of the taking, the manner of the abduction. But see, the treaty or the charter that I just referred to covered that in expectation that state parties to the charter would hide under the excuse of international pursuit of terrorists, to commit renditions, to commit forcible transfer or taking of suspects. In expectation of that, the charter provided its guidelines that even in the pursuit of terrorists beyond your borders, you still have to abide by the due process of law. So that they accuse him of terrorism is not justification for what happened. Rather, it was expected that the accusation of terrorism should have made them more careful to comply with the provisions of the charter on how you can take a terrorist from one country to the other. Well, my brief as counsel is to talk on the legalities. So this is, I think, something that I think is way beyond my brief. I am really concerned about his rights under Nigerian law, under international law, and the manner that this thing happened. You see, there is one very key factor here. He entered Kenya on his British passport, not his Nigerian passport. So on entering Kenya, he came under the protection of two countries. One, Britain, upon which passport he entered, and Kenya, which admitted him to their country on that passport. Well, here we don't have any evidence so far that Britain is complicit in anything, but we have quantum evidence that Kenya is complicit. So Kenya failed in her duties to protect citizens of a Commonwealth country, Britain, that entered. Let's leave Nigeria aside. The only importance you can attach to Nigeria here, the only relevance is just because Nnamdi was born in Nigeria. But when you come to the real analysis of this situation and its import, you look at the passport with which he entered Kenya. So to that extent, Kenya was supposed to respect that passport more than it did, and respect less the place of birth of Mr. Kanu and look to the place of issuance of the passport. Because I'm not saying that this is a hypothesis or my opinion. No, it's provided for copiously in several bodies of laws. One particularly is very relevant. It's called the Hague Convention on Treatment of Dual Nationals. So it applies on all fours to Nnamdi Kanu, because Nnamdi Kanu is a dual national of Britain and Nigeria. So it says if a dual national is found in a third state, in this case the third state is Kenya, that third state in all matters shall treat that dual national as if is a national of only one country. One, the country where he is principally and habitually resident, and the country with which he has most contact. In this situation, if you compare Nigeria side by side with Britain, you will agree with me that Nnamdi Kanu is habitually and principally resident in Britain, and he is in more contact with Britain than he is in Nigeria. His family is there, his wife, his children are there, and that is where his business of pursuit of self-determination is located, namely Radio Biafra, which is a legally registered business in the UK, and the indigenous people of Biafra, which is also equally registered. So Kenya, if it was aware of this law, regardless of the weight, regardless of the importance they attached to her relations with Nigeria, Kenya's relations with Nigeria, it was supposed to look to the rights of Nnamdi Kanu, and if he found cause to have him leave the territory of Kenya, they should have expelled him to Britain, not to Nigeria. Well, this is really what came from him. So he's very credible, and his account of it was very vivid. It's something that is not supposed to happen. Under international law, extraordinary rendition itself is by implication an act of torture, because you took a person and pretended to arrest him without due process of law, but then they took it ahead to the next level of physical torture, physical and mental. It was quite grievous. It was something that when he was describing it to me, it really shook me up, and it got me thinking that how could man be so cruel and wicked to another man like this? Just for what reason would any group of persons that felt that they belong to constituted authority or they are from constituted authority subject somebody to such cruel and extreme degree of torture? No, I didn't think that was misunderstood. I think he told me to convey a message to his friends, well-wishers and family, that, you know, they should remain together, pray together for him to overcome the predicament. And his predicament should not be latched on or used as an excuse for people that are close to him to come to some kind of acrimony. That's all. I think someone may have misunderstood that somewhere. Yes, I even said more. I said there's going to be trial within trial, if at all there is going to be trial. This is a very important question, because some of my colleagues who are lawyers really didn't understand what I meant. Because when you say trial within the Nigerian jurisprudence, every lawyer's mind will go to the law of evidence that says that when you exact confession from a suspect through an act of torture, before you come to trying that suspect, the court must conduct trial within trial of how you got that evidence. If the suspect makes an allegation that the confession was through torture, that's not what I meant. What I meant is that the act of extraordinary rendition has to be dispensed with first before it can go to the substantive trial of Nnamdi, because there is no court of law, justice, fairness and equity and conscience that can go over that. If it is presented well, maybe through an amicus curiae brief, directly or through some other means, I think it's something every competent court of law must consider first before it can go to the main trial. That's what I meant by when I said there's not going to be any trial to monitor. That one is what is going to be tried in court first. The circumstances of his forcible to return to Nigeria is a very big issue that blocks any court from reaching the substantive trial. That's my opinion. He's presumed innocent until proven guilty. That's what the Constitution says. So the federal government is making assertions, allegations of certain acts of criminality against him. It's up to the federal government to prove that in court when time comes. And then that is when Nnamdi will now mount his defense. Well, you see, this matter is sub judice. They have not even brought these charges formally. When Nnamdi left Nigeria in September 2017, he had 4 charges facing him as a matter of record. One was conspiracy to commit treasonable felony. Second was treasonable felony by itself. Second one was defamation of the president of Nigeria. And the fourth one was illegal importation of goods. As far as we are concerned, as a defense team, those are the charges that are pending. The federal government has not brought any new charges to encapsulate, to capture this terrorism and all these things more that you see them talking about in the press. My colleague, Barrister Ifeanyi, who is leading the defense in that very treasonable felony matter, would tell us, who will be with him, whether the charges have been amended or not. But until those charges are amended, it's only these 4 charges that we are aware of for now. Okay, well, there's a law in Nigeria that you will find at Cap A9, Laws of Federation of Nigeria. If you go to Article 20 of that law, it says every people shall have the right to self-determination. Nnamdi Kanu is taking advantage of that law to express his wish for self-determination. The law is not necessarily unique to Nigeria. The law is actually a universal law, so it was up to many different nations to adopt it, and Nigeria did. So self-determination is really what it's about. Every other thing that is coming out of that is secondary, is subsidiary to the main issue. The main issue is self-determination, and it's not a crime within the laws of Federation of Nigeria.
Thank you so much for watching that particular video. Feel free to let me know what you think about this video in the comment section below. Like and share this video again. And I appreciate each and every one of you who always share my video, who always come back to support this platform. I do appreciate you all. May God Almighty bless you. I will see you again in my next video. Bye.